The law matters. Of course it does. Welcome once again. I'm Deb Morais, your host and moderator. This long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law matters because the law matters. A better understanding of the law makes you better prepared to protect yourself, your family, and your business. As we present various topics, you may decide that you can handle some issues yourself. If you decide to enlist professional counsel, our goal, of course, is to make you as best prepared as you can be. If you can save time, money, achieve the best results, then we are happy to help. As always, we welcome David Bazaar, attorney David Bazaar from the Bazaar and Associates law firm in East Providence, who continues to weigh in on the various topics that we tackle. So thank you and welcome.
Thank you.
Today, ain't no cure for the summertime blues and the legal issues that you need to tackle now or be aware of. It's post-COVID as of this session, and people are eager to get together. That's great. And as you plan to host the barbecues, the pool parties, we want to help you avoid a wide variety of problems. And also, before you embark on a summer being spent as your children's entertainment advisor and vacation planner, there are some important legal issues that you should consider. And finally, lest you think that you have entirely escaped COVID's grasp, vaccinations present new issues for friends, families, and employers. There are lurking liabilities everywhere, so we're going to get going and tackle a few of those problems. So David, every December near holiday time, we handle social hosting laws and we address the liquor consumption for minors or people who have generally overindulged. So I guess we should start with that. And of course, at this point, we probably need to add in the legal in some states issue of pot. So if you're going to be the host of a summertime party, let's talk about food and beverages. So if your neighbor has sipped too much sangria, and we've said in the past that you would take the keys or give the person a ride home if you were at a party at Christmas time. So what happens if your neighbor is walking home and he falls or has some sort of an accident? Where's your liability in that respect?
So in the summertime, it's actually the same rules as we had in Christmas time and New Year's and in the winter time. It's first and foremost, if you're having a party, in Rhode Island especially, we can talk to, and you're serving alcohol, there is no social host liability established if somebody comes to your house and drinks too much. You're not a professional, you're not selling them the drink, you're not profiting from the drink. They're probably taking the alcohol if it's a party where you just are having a cookout and have a bar set up and people are serving themselves. But if you see somebody who is obviously drunk and has over-imbibed, then as a good neighbor and a good friend, yes, you should call Uber or get a taxi, take the keys, give a ride home. That is just the right thing to do. And that is probably the most important thing you can do, is to make sure that anyone who's come to your house is going to get home safely.
And we've talked about this too. We've discussed dram laws, but suppose you're having a party and you're cooking or whatever. Maybe, is it worthwhile to hire someone to handle the bar and have them have some responsibility to both make the drinks and keep an eye out on the guests?
So I think once you've hired some professional who's getting paid to do that, they should have had probably some training if they're going to be manning the bar, so to speak, and providing the drinks. So that would potentially give some liability to somebody else. So I wouldn't do it because of the liability. I would do it because it might be an easier way to have a party and make sure everybody is taken care of.
And I think the reason that we wanted to review this today is because there are things that are legal considerations, but there are also things that make you a good neighbor or just are reasonable considerations when you're planning to do things.
Yeah.
So it's summertime as we're speaking, and it's time for you to host a party, and you're cooking, perhaps inside, outside, barbecue, whatever, and you have a pool. So while you're tending the Barbie, whether you're alone or you have a spouse who's going to help, a child falls in. Not saying that the child drowns, but just falls in. What are the legal situations that a host has to be aware of under this circumstance?
So if you've invited people over and there's a pool and you know that there are kids who are going to be there, I would say that you have to do what's required of any reasonable landlord, homeowner who has a pool. And there are certain things you're supposed to have, I think, some life-saving devices, a shepherd's hook perhaps, or a throwable, things of that nature. I always would suggest that there's a conversation with whoever's coming over, if it's some parents with their children, that, you know, we don't have a lifeguard, we expect you to watch your children, but it would be also a good idea to have someone vigilant in watching those things. It would help with liability, certainly. And you had also mentioned barbecue and cooking and that kind of thing. I just want to address something that's probably not on your radar, but is another liability issue that I can think of is, let's just suppose for the sake of argument, you're having a cookout with a lobster boil. And so you have those big pots of boiling water and the propane attached to them. And where are you setting that up? That is a homeowner's potential liability. If you don't set that up in a place that's safe from those children who may not have gone into the pool but come by the pot and knock it over on them, or if you set it up in a driveway perhaps and you know someone may drive in or out and someone drives in and hits the setup and there's a fire or something that happens, or if you have people sitting nearby that setup, be careful of where you set those things up and how you do it, because that could create some liability on the homeowner as well.
And that speaks to suits. But while we've had these discussions, again, during the Christmas and holiday December parties, what about the issue about insurance? Not a legal issue, but a different form of protection. Care to speak to that?
Homeowners insurance will protect you against negligence that happens at the home that causes an injury to someone else. So again, going back to the example of I set up my lobster boil in the driveway and somebody hit it and caused a fire or knocked the boiling water over on someone, they may be liable if they were negligent. But perhaps they weren't negligent because they had no idea that there was going to be a campfire or a boiling pot, so to speak, in the middle of a driveway. So your negligence in putting that there would cover the damages to anyone who was injured by that action. So homeowners insurance is really important with liability coverage, just like automobile insurance is important when you're driving. And of course, there's another thing you could get, which is an umbrella policy, which would cover negligence that is either driving or homeowners or whatever it is that you did, that the coverage isn't enough for those underlying policies. It's not enough, so you need to have the additional coverage.
And speaking again, or back on the legal issue, are we at a place where we should have kids' parents sign waivers when they're coming to the pool? I mean, is there a reason to do that, or is it over the top?
I think that might be a little overkill, but I certainly think it's important to have the conversation of whatever the pool situation is, what's expected, what the dangers are, let them know that there is no lifeguard and you need to watch it. And by the way, there are swimmies available if you have those, or did you bring your own? And what your expectations are of people who are coming as your invited guests.
And are you less culpable legally, as well as just being a good neighbor, if you review some of those issues before the kid hits the pool or when the parents walk in the door and get ready to start the party?
I think the answer is yes to both of those questions. I think that would help with your liability, and certainly it's the right thing to do as a good host or neighbor.
Yes and yes. So addressing or speaking to your issue about the lobster boil, how about instead another issue, at the backyard barbecue, you also decide that you're going to have a lovely dessert, and it's flaming baked Alaska, and it ignites your guest's shirt on fire, or whatever, those kinds of ridiculous kinds of catastrophes. Is that a legal liability as well as a personal one? I don't know.
Well, it could present liability if you did something negligently and it caused damage to someone.
Yes.
So there were cases that talked about restaurants where they serve bananas Foster or whatever you might light on fire and get somebody, catches somebody on fire and causes damage. I would say that if you didn't act reasonably, as the normal, reasonable person would do in the circumstances, and you were negligent in putting too much alcohol in the flambe and lit somebody on fire, you're going to be liable for that. That's where your homeowner's insurance is going to have to step in.
Also under the realm of what's reasonable, your shrimp on the Barbie, it was bad. Your chicken salad had mayo that soured. Maybe you had it out a little bit too long, but maybe you didn't. Maybe you purchased it. All of these things seem fairly strange, but certainly they happen.
Sure. And so if there is the ability to reach back down the line to whoever sold the product that was defective, your visitor, guest, friend, neighbor may be able to sue the person who made the defective product. And so even though they didn't buy it, there doesn't need to be privity of contract. That's case law that goes way back that says at one point in time, the only one who was protected from the defective product was the person who bought it. No longer the case, not for many, many years. Not from before I went to law school, which is like the ancient days. So you could sue if there were some product that caused the injury, the bad mayonnaise or the, what was the other thing? Bad shrimp?
Bad shrimp?
Bad shrimp, whatever it is. Now, if you did something negligent as the homeowner and caused the injury, then you could still be liable as well.
So if you didn't taste that shrimp first, if you didn't taste that salad first, and you didn't know, and how reasonable is that? How far does that go? What are considered reasonable limits on what could actually happen at any given time?
So I don't know that you necessarily have to taste it first, but if you know it's bad and you
Different
serve
story.
it, yeah, there's perhaps liability there. If you had no reason to know and it wasn't your fault that it was like that, then the lawyer, as the lawyer for the guest, I would want to, hey, where did you buy that? And when did you buy it? And do you have a receipt for it? And can you help me with this information? And see if there's somebody you could reach back to that caused the injury.
And would it be difficult to say, we know that fishmonger had bad shrimp, or that grocery or specialty store had it sitting there? Wouldn't it be hard to prove, or would it not be?
Sometimes it is, and sometimes it's not, because it makes me think back to, remember when we had the case where people were getting sick from the bad Zeppelas?
Yes.
And so it usually will be more than one person who gets sick. And so it's reported, and you can go back and trace it and find where it came from.
Good to know. And let's go on to now popular at parties and otherwise, weed. You're the host, and never mind alcohol, now there's weed. So in two different scenarios, say your state has legalized cannabis, as it has, say, in Massachusetts. However, if you're hosting a party with kids of mixed ages, what's your legal responsibility in supervising the party in the first place that no underage kids have it, and that there's not some excess that causes an impairment that could be a problem? What's your liability there?
Well, remember, with alcohol, there's a difference between the social host law for people who are of age and are responsible, theoretically, adults who are serving themselves or drinking at your house, as opposed to serving underage people, children, who aren't allowed to have alcohol, and there is liability and responsibility for what may happen as a result of serving children. I'm going to say that although I haven't seen any cases on this yet, but if we're in a state where marijuana, cannabis is legal, and you allow children at the party to use it, which is not legal, you're probably going to face the same liability and have the same issues as you would with alcohol.
So children love those little gummy bears. Mixed in are the laced gummy bears. I didn't know, and I'm the host. I thought they were all fine. I didn't taste those. Are you culpable? Because some kids could say, let's just mix it in for a few
Yeah.
whatever reasons.
You
lapse.
have a responsibility to exercise reasonable or due care in making sure that nobody is getting anything that they shouldn't otherwise have, whether it's alcohol, laced gummy bears, marijuana, or whatever it is that you might have.
So what about the impairment? Someone has one too many gummies or one too many tokes, and they suddenly have this wonderful and new sense of humor. And are you expected as a party host to know whether that also would impair their judgment if they are getting in the car and driving? It may or it may not. Are you responsible for that?
Potentially. No more responsible for that, I don't believe, than you would be with the alcohol situation. So if it's a child who has used your marijuana or eaten your gummy bears or whatever it is that have been laced or has marijuana in it or cannabis, then just like with the alcohol situation, and there are cases in Rhode Island where a child drank alcohol at a party and then because of being under the influence of that alcohol, hit somebody or did something where they weren't being supervised correctly and were allowed to drink, that the homeowner was liable potentially for the damage they caused to someone else. That could follow the same routine with using marijuana or allowing marijuana to be used at your home by an underage person.
Good to know.
No case law on it yet, but that would just be my analogy and analysis of the two types of situations and how they're similar.
How about this scenario? So Rhode Island right now hasn't legalized recreational pot. You know some of your guests, you're a Rhode Islander, you know some of your guests come from another state where it is legal. What is your responsibility in that situation to make sure that none of those products are used during your event? Are you obliged to know all of this? What's legal? What should you do? What's your advice?
My advice is to tell people if you see them using marijuana at your party in Rhode Island where it's not legal, say, yeah,
Not
you
here.
can't do that here. Not here. And just make sure they know that and make sure they don't.
And the gummies that you wouldn't know about?
You can only
Do what you can.
safeguard against what you know. So, you know, if somebody went to a bar and then came to your house, there's nothing you can do about what they did at the bar. You can safeguard and protect about what they might do at your house that you know of. So I would say you have an obligation, if you see it, to stop it.
And so, not legal, but people used to lace brownies, as the Alice B. Tokeless brownie situation happened years ago. But we know that some of those things continue. But to your point specifically, if the host doesn't know, they can't be really culpable, or at least they have somewhat of an option to say, I really didn't know and I couldn't know.
Remember, with negligence, it always goes back to the reasonable person standard and what would a reasonable person in the same circumstances do. And really the question is, what would the person in the same circumstances be able to do? If you're not aware of it, you can't guard against the dangers that might come from it. So there's probably no negligence, because you can't be held liable or responsible for breaching a duty if you didn't even know that existed.
Good for people to know. And the controversial topic about vaccinations. You're hosting a party. The vaccinations aren't on the menu, but they could be on other people's agenda. How would you address that? So you're the host, and you shouldn't be allowed, I guess, to ask everyone, have you had a vaccination? Or can you ask that? Should you ask that?
Well, let's talk about that. This isn't the government asking. This
Right.
isn't an employer asking.
No, we're talking about just you as the party host
we
right
are
now.
in a social situation, your home, your party. I would suggest that you're allowed to ask people who you've invited over what their status is, and act accordingly as to what makes you comfortable. So if you're inviting people over and you're saying you can come, but if you're not vaccinated, I really don't want you to come, you should be allowed to ask that. It's your home. And if somebody is not vaccinated and you're not comfortable with it, you know, that's going to be your own personal issue with your friend or relative or whoever it is. Or if you say, you can come if you're not vaccinated, but I want you to wear a mask, and they don't want to wear a mask, then you don't have to allow them in your home because it's your home. So you should have the right to say who can come to your home and under what circumstances.
And the guest, or if they're parents, my child isn't vaccinated, can you assure me that everyone is vaccinated? My child might be immunocompromised, or maybe I'm just concerned.
Yeah.
What's the guest's option and what's the host's?
So the
response?
host can say, if this is what they did, I've asked all my guests to tell me and agree to come only if they're vaccinated, but I can't guarantee that everyone's honest and is telling the truth, and that's the case. So if you're uncomfortable bringing your child to my house under these circumstances, I totally understand if you don't want to do that and leave them at home with somebody else.
So what you've just said, David, is so very reasonable. We hope most people are reasonable. Is that a little bit different from whether they're legally responsible to say that? Are you legally obliged to do that? Again, this is a private home. I like your response, and it's so reasonable. Is it a legal issue or just the common sense thing?
It's more of a common sense issue.
Okay.
I mean, legally, you can ask. Legally, someone doesn't have to respond. So it just becomes more of common sense is, you know these people, you've invited them to your house, you have a relationship with them, you have to figure out what's going to work best, not only for yourself and for them, but for all your other guests as well.
Okay, so let's talk about another situation, your vacations for yourself or your kids. There's more planning than where you're taking your beach balls. So before you pack up your kids and their towels and whatever for the beach, especially if you're going away, we often address the idea of wills, estates, guardian plans. What minimally should someone do without suddenly having decided that in a week we're going to go away and I can't possibly put together an estate plan? What's reasonable, David?
So I used to have an attorney I worked with who would get the call. I'm going away next week, I'm going with my family, I'm concerned, I want to have all my documents in place before I go. It's never going to happen. And he used to tell them, it's okay, yes, let's set up an appointment for when you're back. You should absolutely have something in place anyway, but don't worry. And of course, I don't know if this is the best thing to have said, but he would say, I haven't lost anyone on a trip yet, so I'll see you when you get back. Now, of course, you can't really say that because you never know what's going to happen, and you would like to have things in place, but a week before you go on a trip isn't the time to do it because it's not going to get done correctly.
Does it make sense that you should or could at least a week in advance have some designation regarding a guardian should something happen to you, your spouse, or however that goes? Is that at least a reasonable thing? Is that a necessary thing?
Well, anything you can get done is reasonable. It should have all been done in advance.
Sure.
So if you're able to get it done, absolutely. Can you get who's going to be my children's guardians if something happened to me? That's probably in a will, so you'd have to get a will done. Can you get it done? If you're able to, of course you should get it done. I'm just talking practically is to get something like that done with an attorney in a week doesn't sound reasonable to me.
Okay. And these days when there might be a father-daughter, father-son vacation, in other words, only one parent taking an underage child, apparently there are new rules, laws governing how you can take that child on a plane out of state, out of the country, out of the area where they both live. What can you say to that?
So I don't know if there are new rules, but there have always been rules that one parent can't leave the country with a child or children without something in writing from the other parent as well. And it's usually a note notarized and that the airplane personnel will be comfortable with, because that's always been the case, at least leaving the country. Traveling state to state's different. It's the United States of America, believe it or not, and you can go from state to state, and if it's not being done correctly, you're going to end up with an Amber Alert or something of that nature if one parent is actually taking a child without the agreement or permission of the other parent as well. But for the most part, leaving the country is an issue that has to be addressed by both parents before you go.
Okay. And for the children that you're sending away, I mean, escorting to summer camp, there's always paperwork, and probably thanks to lawyers, there's even more documentation than ever, lots of fine print. What do you say that parents need to be most aware of? Because undoubtedly a kid maybe gets homesick, or maybe something minor happens, something major happens. What do they need to be aware of?
So probably the camp is having you sign a contract, a release, another release, a release for the special trip that they might make for leaving the camp to go somewhere else on a field trip or whatever. So the camp is trying to protect itself from anything that you might claim shouldn't have happened. And you're signing usually releases about hazards that are known and so forth and so on. The question would be is how effective are those releases if something happened that the camp was really negligent for and didn't guard against, and it wouldn't have been something that you said, hey, I never anticipated that and signed a release for that. So generally speaking, it all goes back to what is the language in the release or the contract that you're signing, and what state are you in, and what's allowed to be released in advance of the negligence occurring.
Okay. And finally, speaking on behalf of employers who might have summer hires, are they allowed to ask if someone's been vaccinated? I understand it's not legal to say, have you had COVID, Mr. Bazaar? But can they ask, regardless of what the position is, whether or not the person's been vaccinated?
Yeah, so there's different interpretations in different states and by different attorneys as to what an employer is allowed or not allowed to ask. Certainly, given it depends on, I believe, what type of employer it is, what kind of business it is. There are certain businesses where knowing that is going to be crucially important. I can think of nursing homes where you have elderly people who are living there, and you don't want to get them exposed, even if they've been vaccinated unnecessarily, by hiring, I'll say, a CNA or other employee who's not been vaccinated. So I think it depends on the circumstances, and that's all stuff that's still going to start being developed and coming out as we go along.
I think that we've been hearing that there are more and more who want to ask but are very unsure about it, so I'm sure that that's going to continue to be in the news for a while. Well, we hope that this helps allay some of your concerns about summertime issues and summertime blues. Stay tuned to The Law Matters. As we say, it matters to you. Thank you.